Tonight I'm speaking about transparency, public participation, and constitutional principles that protect every resident's right to engage with their government. The First Amendment exists to protect speech, dissent, and the right of citizens to petition their government for redress of grievances. Those protections do not disappear simply because public discourse has moved from town square to social media. In March 2024, the United States Supreme Court issued, and Frank, you'll like this, it was unanimous decisions in Linkty versus Freed and O'Connor, Ratcliffe versus Garnier. These cases addressed when a public official's social media activity is subject to First Amendment constraints. The court recognized that when public officials use social media to communicate government business, announce official actions, discuss public policy, and interact with constituents, constitutional concerns can arise if citizens are excluded from participating in those discussions. Ask our city attorney to supply you the case law so you can further understand. The Supreme Court established, and Linda and Frank, you really want to listen to this, that an official may be acting under the color of law when the official possesses authority to speak on behalf of the government and purports to exercise the authority through social media communications. When those conditions exist, the official's actions are subject to First Amendment scrutiny. The court's message was clear. Government officials do not have unlimited authority to silent criticism simply because that criticism appears on a social media page connected to their public role. The public should be concerned whenever an elected official uses social media to discuss city business while blocking criticism, deleting dissenting viewpoints, cutting off microphones during public comments, or restricting participation from residents who simply disagree. The concern becomes even more serious when appointed commissioners, board members, or volunteers are instructed to not engage in public discussion, not to voice independent opinions, and not to participate in the democratic process, as we recently saw Lyndon Johnson do regarding the 218 protest. Public appointees don't serve you. They serve the public. Their duty is to exercise independent judgment and contribute to open government. The First Amendment was designed to protect unpopular speech, critical speech, and dissenting speech. Those protections are most important when citizens like us are speaking to officials like yourself. I urge this council to adopt and enforce policies that respect constitutional principles, encourage public participation, ensure government communication, whether in council chambers or on social media. It should be that it remains open, accountable, and accessible. Remember, the ACLU...
Thank you. We have Carrot Chauhan next. Thank you, Carrot.